This is Kevin McNeely with the Design Patent Law Update, and I'm discussing a decision from the Federal Circuit in which it was reported that the title limited the scope of a design patent claim. So this Court of Appeals decision was Curver Luxembourg versus Home Expressions, issued on September 12th, and it was on appeal from a district court of New Jersey. The design patent in question, the 677-946, had a title Pattern for a Chair, and it consisted of 5 drawings. The 5 drawings were simply of a Y pattern, kind of a panel that was part of the chair. So there was no actual chair shown in any of the drawings. Here's a image of the accused product from Home Expressions. It was a basket with a Y design similar to that disclosed in the 946 patent. So the district court went through the two-step analysis that's set forth in the Egyptian goddess case, construing the scope of the design patent and then comparing the accused product to the claimed design. When they did that, they determined that the scope of the claim is limited to a chair. So based on that, they found that the Home Expressions product could not infringe, and the case was disposed of on a motion to dismiss. So a couple of important points from the Federal Circuit decision. Design patents are granted only for a design as it is applied to the article, not a design per se. And claim language can limit the scope of a design even if that language isn't apparent from the drawings themselves. And of course, the Patent Office doesn't grant patents for designs that are disembodied from an article of manufacture. This is not new information. These are sort of well-known points. So a couple of practice points here. First, is this a significant case law development? We started out by stating that the claim was limited by the title, and that's how it was reported in the AIPLA, and the court itself said that this was a case of first impression in determining how the title impacts the scope of a design. However, the title change that was required by the examiner propagated through the entire application. So the claim language itself in the description of the drawings was changed to a pattern for a chair. So whether the title limited the scope of the design is really not really an accurate way to describe this case. That leads to a discussion whether the 946 patent should have been granted in the first place. Arguably, it was an indefinite disclosure. It simply shows 5 square panels of a Y pattern that could really be part of anything. And the issue, however, wasn't raised during the appeal, so it remains to be seen whether or not that would even be held to be an indefinite patent. We always, of course, look for broad generic titles to the extent possible, but again, the tension here is an examiner is going to try to restrict the scope of the title. And in this case, of course, the prosecution history, the examiner did require that change to pattern for a chair. So one other point to consider is that sometimes you can file a single design patent with different product embodiments. And I illustrated design 572952 as one of those patents. This is for surface ornamentation for furniture, and it's applied to items such as cabinets and a mirror, And the design is it's a weave pattern. The details of the furniture are disclaimed, but it's shown in a linear format along with a circular format. So it could be something that could help, but it's not clear under the facts of this case that other than filing for a weave pattern for a storage bin, that there could have been anything for a meaningful scope of enforcement of a design patent. So that's the end of the discussion. I've provided case materials below that include the patent application and some of the prosecution materials, along with some of the materials from the motion to dismiss. Thanks for watching.